Hi, I'm Denise and you're watching Law with Denise. In this video, I'll be doing the following. I'll be outlining the facts of White and Chief Constable of South Yorkshire. I'll be explaining what was decided in the Court of Appeal at first instance and in the House of Lords with this case. And then finally, I'll be looking closely at the House of Lords decision and exploring why it was that the House of Lords refused to extend the common law with regard to rescuers. So let's start by exploring the facts of this case. Now, this case arose out of the Hillsborough disaster, which occurred on April 15, 1989 at the Hillsborough Stadium in Sheffield, England. Now, if you're not exactly sure with what happened in this disaster, I do have a video in which I explain the details of what happened. Secondly, if you'd like to watch a case summary of White and Chief Constable South Yorkshire, I do have a video on that as well. So you could go ahead and watch that and then come back to this video if you wish. Now, this case concerned 6 police officers who argued that they were exposed to things, they were involved in things which led to psychiatric injury on the day. Let's first outline who these officers were. So they were Bairstow, Bavis, Glave, Mr. Hallam, Miss Smith, and White. These are the 6 officers that started this case at first instance. And who are the defendants? The defendants were also officers, but they're senior officers, and they're senior officers who were responsible for what was happening at the stadium on April 15, 1989. But when we look at White and Chief Constable of South Yorkshire, it is only one officer, that's the Chief Constable of South Yorkshire. It is only he that is being dealt with regard to the aim for psychiatric injury. So what needs to be made clear, I think, as students of this subject is that these 6 officers were not the only officers on the day of the disaster, working at the stadium on the day of the disaster, right? And these were not the only 6 officers that started claims. There were loads of officers working on the day. And in fact, there were 52 officers who started claims against the senior police officers. And it seems as though 14 of those officers were handed down judgments that the defendants did not argue against. So what I'm saying is that the defendants didn't come back and say, we're not liable for that. But this case goes all the way up to the House of Lords because the defendant, the Chief Constable of South Yorkshire's position is that he was not liable for these officers, these particular officers' psychiatric injury. Why is he saying that he's not liable, or why was he saying that he was not liable for these particular officers' psychiatric injury? He's not arguing that they didn't experience what they did. He's saying, yes, I accept. In fact, the officers, it was not an argument as to whether or not the officers were negligent. That was agreed that there was negligence on the day. When we look at the facts and we look at what it was that these particular 6 officers were doing, and we compare it to what the other officers were doing, it becomes a little bit clear as to why this case was concerned with a question of liability. I've told you who these officers were. I've told you who the defendant is. Now let's look closely at what exactly these 6 officers were doing. Miss Smith was not actually at the stadium when the disaster occurred. So she acted as a liaison officer between the stadium and one of the hospitals where some of the victims were taken to. We had other officers who were involved in moving bodies out of pens. So we had White, who was actually involved in moving bodies out of pens, pens 3 and 4. Now, it's important, as I said, if you don't know the details of what happened on the day, it's good to watch the video I have. The link is in the description. Because the disaster happened at the stadium, we often say, but as students, you need to be absolutely clear in knowing that the actual disaster occurred in pens 3 and 4 of the Hillsborough Stadium, so not the whole stadium. And this is important for us to understand where these particular officers were, right? So when we look at White and Chief Constable South Yorkshire, we're looking at 6 officers, right? One who wasn't actually at the stadium when the disaster happened. And we're looking at officers who were not actually working in pens 3 and 4 where the disasters occurred. This is why there is this argument of am I liable for their psychiatric injury? They weren't in the part where the disaster occurred. But the officer's argument is, we helped. We were not stationed in pens 3 and 4, but we rescued. We got out. We took bodies out. I was at the hospital liaising. I saw things. I helped. I tried to help victims. I worked with families. And as a result of me doing all these things, because you, Chief Constable of South Yorkshire, was negligent, I now suffer from psychiatric injuries, and therefore it is your fault and you should pay me for it. Now let's look at what their actual grounds were. So let's look at what the police officers actually grounds for with their case. They had two, right? So the first was that our relationship with you, Chief Constable, is one that is analogous to employer and employee. Now, it is not identical to an employer-employee relationship, because actually constables are public officers, right? But they said it was analogous to an employer-employee relationship. And in an employer-employee relationship, what the common law had up to then established was that if the employer puts the employee in an unnecessarily dangerous situation as a result of their negligence, the employer can be liable for injury caused to the employee. Their second one, well, not all of them, but some of them argued that they could be seen as rescuers. Now, why did some of them want to be seen as rescuers for the purposes of the law? That's because it had been established up to then that when a disastrous event is created as a result of somebody's or an organization's negligence, it can be expected that someone else or others will step in to rescue victims. And when we step in to rescue victims, if injury is caused to us, damages can be received. And they rest that ground on Chadwick and British Railways 1967. Now, what was said at first instance? The judge at first instance was Justice Waller, and Justice Waller did not buy any of this, so he dismissed all the claims. So all the officers failed at first instance. And this is what Justice Waller said. In response to the first ground that this relationship with the chief constable is one of employer or analogous to the employer-employee relationship, Justice Waller said, well, actually, not really. His argument was that we should expect officers to be more able to deal with these type of disastrous events more than the ordinary bystander, the ordinary person. So you're an officer, you should be able to deal with this a bit more. And so it is not exactly employer-employee relationship. He was very interested in that aspect of it. No, not quite, right? So he wasn't convinced. With response to rescuers, he said, again, you've got to be a little bit more hardened to these events. And yes, there could be situations in which your employer does expose you unnecessarily to unnecessarily to danger as a result of their negligence, and you act as a rescuer and you could be offered damages. But if the court is going to offer you damages, Justice Waller said, we would need to be able to see why it is just and reasonable to do that for you as an officer, but not an ordinary bystander. So after this decision at first instance, 5 of the officers appealed. In the Court of Appeal, we had 3 Lord Justices examining the case. We had Lord Justice Rose, Lord Justice Henry, and Lord Justice Judge. What did they decide? Lord Justice Rose and Lord Justice Henry agreed that 3 of the officers could recover damages as rescuers. Now, how did Lord Justice Rose decide that these 3 officers could recover damages as rescuers? He said that in order to determine if one could be classed as a rescuer, we need to look at the facts of the case. And he said when he looked at the facts of the case, these officers were actually rescuers. Now, remember, at first instance, Waller Justice does not agree with this. And what I want to point out is that Waller Justice did identify that White could be seen as a rescuer, right? He did point that out because he said, because White went into pens 3 and 4 and he removed bodies. But Waller Justice did say, if you're going to be awarded damages, there needs to be something or things which demonstrate why it is just and reasonable to do so for you, White, when not done for others. Now, in terms of the employee ground, Lord Justice Rose and Lord Justice Henry agreed that Bavis and Hallam could recover damages as employees. And why? They said that in a master-servant relationship, the master or employer has a duty of care to not expose the employee or the servant to unnecessary situations, which are unnecessarily dangerous situations as a result of their negligence. And when this does occur, damages can be recovered. There is liability. Now, Lord Justice Rose did point out that there isn't an expectancy that police officers should be more able to deal with hardened events than ordinary citizens, as Waller Justice had pointed out at first instance. So that was not part of their thinking. Now let's look at what Lord Justice Judd said, right? Lord Justice Henry and Lord Justice Rose are in agreement, but Lord Justice Judge is not in agreement. And why not? He says that he is not convinced that these officers are primary victims. He is convinced more that they are secondary victims. And why? Because they were not within the area of danger. They were not exposed to danger. He is saying that their position is one of witnesses, secondary victims. So if they are secondary victims, they need to, Lord Justice Judd said, pass the control mechanisms outlined in Alcock and Chief Constable of South Yorkshire 1992. If you're not sure what happened in Alcock and Chief Constable of South Yorkshire of 1992 and you're not sure of the facts of the case, go and watch my video on it. The link is in the description, and then return to this video. What's the first control mechanism? That there is a close tie of love and affection between the secondary victim claiming and between a victim of the disaster. How could that be established with the officers? Lord Justice Judge is saying it can't be, because you're not related to them. So he thought all claims should be dismissed. So there is an appeal by the defendant to the House of Lords. Okay, so let's move on to the House of Lords. So who did we have in the House of Lords? We had Lord Brown Wilkinson, Lord Gough of Cheveley, Lord Stein, Lord Hoffman, and Lord Griffiths, right? So we had these 5 lords in the House of Lords dealing with this case. Now let's look at their take on the employer-employee relationship ground. They agreed, they said, yes, this relationship between you and the senior police officers was analogous to an employer-employee relationship. And they said, yes, in such relationships, the employer has a responsibility to not expose the employee to unnecessary dangerous events, to not cause them physical injury. But they said, you cannot recover damages for psychiatric injury if we are not convinced that you were exposed to physical injury. If you want to recover damages for psychiatric injury, you must have first been exposed to physical injury. Why do we think they said the officers were not exposed to physical injury? Because they weren't in pens 3 and 4. Yes, you are an employee. Yes, the senior officers owed you a duty of care as employers. Yes, damages can be recovered for psychiatric injury, but you're missing the first step. The first step is you must have been exposed to physical injury, and we do not see that here. So on that ground, they failed. Now let's explore the second ground, the one of rescuers. This one is really interesting, really interesting. Why? Remember, with this one, the officers are trying to get damages as primary victims, right? But what does the House of Lords say to this? Do they follow Chadwick and British Railways boards, or do they not? The House of Lords is forced with this question of extending the common law, they say, on rescuers, because they're claiming that these officers' situation is somewhat different to Mr. Chadwick in Chadwick and British Railways Board 1967. How are the Lords getting to that conclusion? Well, they argue that It's different because Mr. Chadwick was actually in the zone of danger, right? Mr. Chadwick goes out after the Lewisham crash in 1957, train crash, and they're saying he was in the zone of danger. He could have been exposed, but you are not in the zone of danger, police officers. You are not in pens 3 and 4. And then they're saying, should the common law be extended to allow for damages to be recovered when one is not in the zone of danger? Should there be some special category for people who offer assistance after the event, but are not actually in the zone of danger when the disaster occurs? And they say no. And I want to make clear that Mr. Chadwick was not actually out there when the crash occurred. It seems as though, right, the reason for this decision is influenced a lot by the Lord's uncomfortable feeling of offering damages to police officers who are part of the same institution that were responsible for the suffering caused to the victims on the day and their families after. So having passed through the first instance and failed, gone to the Court of Appeal and being told that they were rescuers, some of them were rescuers, some of them were employees. By the time they get to the House of Lords, the House of Lords said, no, we are applying Alcock and Chief Constable 1992. Based on that, you are not primary victims, you are secondary victims, and you are not able to pass the control mechanisms laid down in Alcock and Chief Constable 1992 as secondary victims. So therefore, the police officers would not recover any damages. I hope this was useful. I do have one question for you. Do you think the House of Lords reached the right decision? Do you think the House of Lords should have awarded the police officers damages, if not for as employees, but as rescuers? Are you convinced by the distinction between Chadwick and British Railways Board 1967, or are you not? Until next time, bye-bye.